Good morning. Happy Friday. I hope everybody has a wonderful weekend planned. I hope you have lots of fun. I hope you're in the Christmas spirit. Merry Christmas. So we've had two pieces of news come out. The number one thing is Earl's petition for en banc review. That's where the whole Court of Appeals, the first layer of review, that has been denied. So he's not done yet. I mean, assuming he has the money to continue, etc. His next step would be a petition for writ of certiorari to the Texas Court of Criminal Appeals, which is their criminal Supreme Court, essentially. Texas, for some reason, has a Supreme Court for like civil stuff and a Court of Criminal Appeals for their criminal stuff. So it's same tier as the Supreme Court. They just bifurcated their top level court system for reasons I don't understand, but it's Texas and they do things Texas style down there. And then assuming that he loses that, which almost certainly he will, like they'll probably just deny the petition outright. Like they won't even look at anything. They'll just be like, yeah, petition denied. Very few cases get the Supreme Court level review, generally speaking, in the state or in the country. And then from there, he could still go to the federal court system and do a petition for writ of habeas corpus and run it up the federal system until he runs out of money or until time lapses and he actually gets released for reasons. So there you go, right? So Earl's odds just plummet each step of the way. Like he had basically a 50-50 shot at trial. And then because the appellate level reviews and because these further reviews are basically going to be looking at procedural issues, not the underlying evidence, they're just looking at procedural issues. Was the underlying trial fair enough? Then, each level of the way, they're going to look and be like, well, all these other courts have found it this way. And whether they should or shouldn't is immaterial. They're going to look at the record. They're going to see what happened at each step of the way. And it can't help but reduce the odds of each step. So anyway, that's Earl in a nutshell. He's, I still don't think the trial was fair enough. I don't. And you're going to say, well, the Texas Courts of Appeals disagree with you. Yeah, it's my opinion. And my opinion in this matter is probably wrong. In theory, my opinion on the matter could be proven right at some level of the appeal chain of process kind of thing. But it's just my opinion. As far as Rusty Moore is concerned, I finally managed to get on. I had been trying to get on to their appeals website. I don't know, I guess I gave up when I made that last video on Rusty Moore is almost certainly going to take a plea, but I managed to get on. I thought of it for reasons unknown yesterday, and I managed to get onto the Minnesota Court of Appeals website, and I looked up the Supreme Court petition, and that petition was denied. November 26th, the Supreme Court of Minnesota denied the petition. There was no review. They didn't look at anything other than the petition for Supreme Court review, and they denied it. So Rusty's appeal process is done. And as we covered in my last video on Rusty Moore, basically he's going to, according to the letter, email, whatever it was that his attorney sent to the trial court on the criminal matter, the plea deal was basically done. It just wasn't finalized because they're waiting on the return from the Supreme Court. Now, some people thought that it was a Supreme Court review of implied consent generally. It wasn't. It was an implied consent hearing for the commissioner, whatever their DMV is, Department of Motor Vehicles, whatever they call that, like Public Safety Commissioner or something like that. It was an appeal from their decision that the state had showed that, yes, he was taking Adderall. That I don't think Rusty denied that. But Rusty had a burden of proof. Rusty had to show that he, A, had a prescription, and B, he was taking it according to that prescription. He had that burden of proof, and Rusty failed to show that. So he lost that case. The issues in that case were appealed. So it wasn't taking on implied consent generally. They just call it an implied consent hearing. So there you go. So the only issues that Rusty was taking up to the Supreme Court was whether or not he had shown satisfactorily that A, he was taking a prescription, or A, that he had a prescription, and B, that he was taking the medication according to the prescription. And he failed that because, number one, he never gave the trial court for the revocation of his driver's license, he never gave them an actual prescription. He gave them something from like CVS or something like that, where it showed that they had received something, but he didn't give them the actual prescription, which was dumb, number one. But number two was a huge failing on the part of his attorney. And then number two, he didn't show that he was taking it according to his prescription. Remember, he had a half a pill left in his bottle, and his prescription was to take one pill in the morning, every morning. How do you end up with half a pill? That's a great question. So he said that he, like on weekends where he didn't need as much, he would just take half a pill. But again, that's just showing that he deviated from the prescription. So how can he prove that on the day he took it according to prescription? Well, what he could have done is he could have got an expert to come in and testify that the level of amphetamines in his system at the time that they did the blood test were consistent with someone who had been taking the prescription. But he didn't do that, which is dumb, and again, a failing of his attorney. Now, in the meantime, the criminal case had been on hold, essentially. It's a completely different case with a completely different standard of review. Now, it's the same issues, but because the state only had to prove by preponderance of the evidence, I believe, that Rusty Moore, or maybe even clear and convincing, I'm not sure, but it's a civil matter. What Rusty lost was a civil matter, the revocation of the driver's license. It's a different standard of review, and it wasn't in front of a jury, et cetera, than the criminal case. So even though in the civil case, in the public commissioner case, the implied consent case, the driver's license revocation case, even though in that case he failed to carry the burden of proof, the criminal case is different because the state has the burden of proof, and then he can raise the prescription deal. In the criminal case, a completely different trier of fact will look at these issues. They can propound evidence in this case. In the criminal case, again, they can make up they can solve the issues. I mean, assuming that they have a valid prescription, number one. Number two, they can prove that Rusty was taking it according to the prescription. And number three, they could prove that his the amphetamines in the blood sample, the blood test, were consistent with him taking his prescription via an expert who would testify that, this is what the expected parameters would be at this time if he had taken a pill every morning for the last however many years. This is the expected level of amphetamines in his system. And yet they're not going to do that. You think about it. They're not going to do that. Why aren't they going to do that? Because either they don't have a valid prescription, which is unlikely, or number two, he wasn't taking it according to the prescription, and an expert would not testify that the blood sample, the blood test would show. You know what I'm saying? So if he could prove it, considering that he took it all the way up to the Supreme Court on the driver's license revocation, if he could prove it, why wouldn't he spend the money on the attorney to prove it at the trial in the criminal case? Think about it. The attorney in the criminal case probably said, look, we just don't have the proof. We can't prove what we need to prove. All the state has to prove is that you were taking amphetamines. That's all they have to prove. You were on amphetamines. You're driving under the influence. You're driving while under the influence of drugs, right? Boom, their case is done. We won't prevail on our affirmative defense that there was a prescription, that you were taking it according to the prescription, and that your results are consistent with you taking it according to your prescription. If they could prove that, they would. But they're not going to. They're going to take a plea. Why are they going to take a plea? Because they can't prove it. The defense counsel told Rusty, look, the state can prove what they need to prove. We can't prove what we need to prove. You need to take a plea. So on the 17th, Rusty's going to take a plea. It's going to happen. Sorry. For all of you people who said that cop should be the one on trial. That cop screwed up. Rusty passed his field sobriety checks. This is total bullshit. Rusty's innocent. He should be free. This cop singled out Rusty for reasons that you can't articulate and decided to arrest him, even though, according to you, he wasn't intoxicated. According to you, he passed the field sobriety tests. But for reasons unknown, they just decided to arrest this guy because, you know what? F Rusty Moore. The state just has it out for him. He has a rap sheet a mile long. But it's not Rusty's fault. He's a good dude who doesn't do nothing wrong. Okay. So for all you idiots, especially Audit the Audit, who thought, oh, Rusty's this total bullshit. Rusty's going to take a plea. And he's going to take a plea because he knows, and his defense attorney know, that they're going to lose a trial. It's simple as that. So they're going to cut the best deal they can, considering the charges, considering Rusty's rap sheet, which I'm assuming is going to play out as far as what kind of sentence he's going to get. You know, and I hope, knock on wood, I hope that he doesn't get jail time. I don't like to see people get jail time. You know, he didn't kill anybody. He was just driving like a dumbass, apparently, allegedly, while under the influence of too much Adderall, apparently, allegedly. So, you know, I hope he doesn't get jail time, but he's going to get something, you know, and God help him and his family over these trying times. I mean, this isn't going to be fun, but sorry, your boy Rusty done screwed up, you know, your boy Rusty done screwed up. So good luck to him. I hope you get a good plea deal, and sorry for all the Rusty fans out there, but your boy done did it. Thanks for watching. Have a great day.